Thank you, Mr. Chairman and members. This bill is called the Louisiana Energy Protection Act. Its purpose is to prevent lawsuits against fossil fuel companies, against people, against businesses, against government agencies, against nonprofits, for a claim for damages related to climate change. And to be clear on that, it is strictly limited to claims for damages caused by climate change. And let me give you an example of that. In the state of Washington, Juliana Leon died of a heat stroke. She was a middle-aged lady, as far as we know, healthy, a great community advocate, tragically passed away from a heat stroke. Her heirs filed a suit against fossil fuel companies in that state, claiming that their mom died of a heat stroke because of climate change, and then attributed the emissions from fossil fuel companies to the change in the climate, which therefore caused her to die. And that is absurd, because you couldn't even identify which one of the industries actually did the emissions that caused the damage, so you just filed a claim against all of them. There's over 40 claims across the country right now. About half of them are still active. The municipality of Boulder, Colorado is filing a claim against fossil fuel companies in Colorado based off of insurance rates for homes, saying that it's causing inclement weather and it has to be their fault from the emissions. Negligence, nuisance, product liability, all the same kind of claims that they can file currently, but they're filing it as a climate change damage. So what this bill would do is prevent that type of claim here in the state of Louisiana. Oklahoma and Utah, I believe, have already adopted legislation or are currently debating it. And Tommy can correct me on that, but I believe that actually both of those states have adopted it. Ours is a little different because it talks about the claim and not the defendant. It just says you can't file a claim based off of climate change damages. It is prospective only. And again, I mentioned this earlier, but it's any person, so any individual, legal entity, public or private, including nonprofit, non-governmental, and government entities. So if you were a landowner and you had a lease with an oil company for a pipeline or a well, and that company was sued as in one of these claims, you too could be swept up in that. So that's one of the reasons the Landowners Association, the trucking industry, logging, Farm Bureau, and others have supported this bill as well. So with that, I know you'll have questions, but I'd like
I see Mr. Tommy Fauché at
to
the table.
recognize Tommy.
Mr. Fauché, could you introduce yourself, please?
Sure. Thank you, Mr. Chairman. Tommy Fauché, President of the Louisiana Mid-Continent Oil and Gas Association. And thank you, Mr. Chairman and members, for hearing this afternoon. I want to thank Chairman Guyman for bringing this important bill. There are a few times, I think, in Louisiana where we have really stepped out front, particularly in the litigation space, and this bill absolutely does that. Chairman mentioned the other states that have started to move to pass legislation to bar lawsuits based on climate change. Louisiana, I think, selfishly, and you should hopefully all be proud, will have one of the strongest pieces of legislation. And hopefully once this gets through the process, I think the country is going to look at this and celebrate what has been done on behalf of not just the oil and gas industry, but this also goes further. This means that all businesses will be protected from these lawsuits. All constituents, people who own small businesses, they will all be protected. And so I really think this is an opportunity where Louisiana has a chance to celebrate what it is doing. Clearly, the country is watching. We have seen a lot of national interest in what is happening here. So I want to thank the chairman again. I'd ask you all to please vote to support this. Final point I'll make, because some of these questions came when we were on the House side. This is not a CCS bill. This does not stop people from bringing legitimate claims against businesses or industry if there is harm. This is strictly limited to greenhouse gas emissions and to climate change. Thank you, Mr. Chairman.
And Mr. Chairman, if I could just, I'm sorry to cut you off, but if I could add on that point, I want to say that one more time, that this does not prevent you from bringing a legitimate claim against emissions damages caused by emissions. It's only if you are attributing the damage to actual climate change. And it's preempted by any federal and state law. So Clean Air Act, Clean Water Act, any state, any DEQ permits for emissions, any of those violations, this does not prevent you from seeking damages for any of that. So we were very careful to make sure that we did that. I'm sorry.
Thank you, Mr. Chairman. You did not interrupt me ever. Senator Lambert with the question.
Right. I've got just a couple of questions. I know we have these pending coastal lawsuits that are in the U.S. Supreme Court. How does this affect those? Does this have any effect on those or potential landowner suits? Because I think we gave them a certain period of time to file a suit, either, whether different issues with oil remediation sites, as well as, possibly coastal.
Yeah, go ahead.
You go ahead. We can both answer it, but I think you've got.
Look, I appreciate the question, Senator Lambert. I can tell you the drafting of this bill paid extra attention to make sure that this is about climate change related suits only in the future. This went out of its way to not impact any of the ongoing litigation, any of the cases that you're referencing, including the cases that have gone to, some have honestly been, the Supreme Court has weighed in already. This bill goes out of its way to not impact any of this. This is solely focused on future claims for greenhouse gas emissions and climate change.
So there's no intent to affect those lawsuits in any way?
No, Senator, not at all.
None at all, sir.
All right, because I don't see anything in here at this point that says that.
I'm going to help you out, Senator Lambert.
That's what I'm hoping, that we'll have a little help out, that we make sure it does not affect them.
Thank you, Senator Lambert. The chairman and I might disagree, and I'm sure he's going to say this is already in there, and I probably think it probably is. But I have an amendment, and I'd like to pass out the amendment to put some belt and suspenders, just to make sure that we're not affecting the coastal lawsuits that have already been filed, that might mention some of these words that are in the bill in them. So just make sure that we're keeping it clean.
Mr. Chairman, could I address Senator Lambert while you're passing that out?
You got the microphone, sir.
Okay. Senator Lambert, if you look on page 3, section B, line 22, it does talk about how it basically is prospective, so it wouldn't affect anything that's currently, if that was one of your questions, if anything currently would not be affected by this legislation. I don't know if that answers your question or not, but the chairman's amendment may address it further, but hopefully that helps give a little bit of guidance.
Thank you, Mr. Chairman. Mr. Wilson, could you read in Amendment 3875?
Thank you, Mr. Chairman. Members, this is Amendment Set 3875. It creates an explicit exemption for causes of action filed before the effective date of the bill, and it makes the bill effective on signature of the governor.
Thank you, Mr. Wilson. And members, that's what it actually does. This is a grandfathering clause. All existing, already filed cases are completely exempt from the new ban on climate, GHG-related claims. And it also moves the effective date to the signature of the governor. I think you had it in August.
We did have it in August, yes,
And
sir.
it becomes effective date of the signature of the governor. Do I have any, I make the motion to adopt 3875. Is there any objection to that adoption? With no objection, 3875 becomes part of the bill.
No objection here either, Mr. Chairman.
I do have one more person in support wishing to speak, Ms. Shelley Dunbar with Lobby. Is Shelley? She waves. Okay, so we're good. I have no questions at the moment, Chairman Guyman, but we do have a couple people that would like to come to the table in opposition, if you don't mind. We have Victor Marcello with Plaquemines Cameron Parishes and Marley? Mariel Montgomery with the Sierra Club in opposition, both wishing to speak. And Mr. Marcello, you sat down first. Go ahead and introduce yourself, and you get to go first, sir.
I'm Victor Marcello. I represent the 6 parishes in the coastal litigation that everyone, I'm sure, in this committee is familiar with. I also represent in a law firm that has a substantial number of legacy cases. And we, from time to time, I'll do some regulatory work. And so I just want to try to, I don't want to take too much of your time, but I want to try to explain the context of what we're talking about here. We've had discussions about this before the committee meeting here. We've heard several statements from the sponsor, et cetera, about the scope of the bill, what the intent of the bill is. All that's fine and well, but I don't think there's a lawyer in this entire building that will tell you that if you read the law as that governs interpretation of statutes, the law says you look to the text of the statute first. And you can disregard the history if the text is clear and unequivocal. That's the problem I have with this bill. I think the way this is drafted, it cuts across, and excuse me, because the only clean copy I have of this is on my phone. It cuts across private claims for damage to movable property. It cuts across, it affects administrative claims by DEQ and the Office of Conservation. It affects all the legacy lawsuits. It affects everything that I proposed an amendment. It affects all of the statutes. And I did not draft it. I don't know who drafted it, but whoever drafted it, I question their intent, because it's a lot more, it's a lot broader, much broader than has been represented in the testimony. So I just want to point out some language here to make my point. The coastal cases have been, for a second time, removed to federal court for 8 years, just to talk about jurisdiction. It's amazing that this country can spend all this time and money talking about which court should hear a case. And it went to the U.S. Supreme Court based on the meaning of the term related to. Related to. The argument was that the oil companies' contracts during World War II related to their crude production, despite the fact that the oil companies did not have a right during World War II to refine the oil that they themselves produced. They said it related to. Related to has been interpreted time after time in court after court very broadly. And you have that, and I'll give it to you right here in this, and I'll show you where it is in the statute. The statute can be, with limited modifications, a statute that does what you want it to do, which is to prevent the climate change cases, the 40-type climate change. And I've followed those cases all along since they were filed, simply because they had something to do with the jurisdictional issues in the coastal cases. But those cases are misrepresentation cases, that the oil companies misrepresented the effects of climate change, and therefore we're entitled to money to protect ourselves from climate change. No one in this state has made such a claim, and I doubt if anyone in this state, city, parish, will ever make such a claim. Basically, this bill is a solution in search of a problem. There is no problem. But if you want to pass it, okay, you need to take out this language. So you look at the covered civil liability, and the definition of covered civil liability starts off by saying covered civil liability action for climate change, that defines as an action for climate change, et cetera, then goes on to say brought under statute or under the Louisiana Civil Code or under other sources of Louisiana law that purports to arise out of or relate to or seek relief of any kind arising out of or relating to climate change. I could take it almost, I could we're going to see it. We're going to have lawyers because they got a lot of money. Oil companies there'll be lawyers in court saying, hey, you know, we have damage, we have pollution, we have land loss. It's related to climate change. It doesn't have to be all related to climate change under this bill. Just any little bit of it could be related to climate change. Just like in the case that went to the Supreme Court, just one drop of oil that was refined by the same person that produced it caused a change in jurisdiction. That is what I'm talking about. I'm not saying that if you guys want to go ahead and say you can't file these climate change suits in Louisiana, fine, do it. But this bill does a lot more than that, and I can guarantee you that there's going to be lawyers that interpret it like that. Now, maybe that's not the intent, and maybe a court will say, well, the legislative history, we respect the legislative history. But I'm not banking on that. I'm here, I think when you legislate, just say what you mean and mean what you say. That's what I'm wanting to do. Then you go, then further down, it says arising, you say of any kind arising out of or relating to. Why can't you just say it's directed to climate change? It's an easy way to say it. There's easy ways to do it. So, I mean, anyway, I was going to say other things, but I just want to say that I think that the savings provisions are not adequate, that we need to make some tweaks, if you want to call them that. We need to make some tweaks to the body of the bill. And I think you could accomplish what you're trying to accomplish with those tweaks without affecting legacy, without legacy cases, personal property rights, the rights of the DEQ to enforce their regulations. I can go, look, I can tell you how this will work. It covers administrative hearings.
Mr. Marcello, you have to wrap up. We have a
Okay.
4-minute rule
Okay.
in the bill. in
Okay,
the committee.
I'll give you an example. It covers administrative proceedings. So there's an administrative proceeding against a polluter because he's polluting and he doesn't want to stop polluting. DEQ says, we're going to file an administrative proceeding. So what happens? A Dow Chemical Company, some or other major chemical company, or whoever's polluting has a lot of money. 7 lawyers show up in the building down the street, and there's one little person there that made the decision to start this administrative hearing, and they say, we're immune. We're immune from this because this is an administrative hearing, and that is in some way related to climate change.
Thank you, Mr. Marcello.
Thank you.
We see no questions. Go ahead and introduce yourself.
Sure thing. Good afternoon, folks. Marilyn Montgomery with Sierra Club. Our contentions with the bill are very similar. We would also like to see the bill amended to state that any litigation brought that would otherwise hold water, that this bill does not discount that this bill does not make that impossible. Specifically, that it does not immunize or relieve civil liability for any of the petrochemical companies, any of the CCS infrastructure or companies, any of Louisiana's industrial sector companies. So that specific language we would like to see added to the bill. And also to say that any cases brought that would otherwise hold water, any cases that would otherwise be negligence, are not discounted, similar to my colleague at the table here, simply because perhaps the plaintiff has their own personal beliefs about climate change or has their own personal beliefs on how whatever is the cause of action for the case relates to climate change. So we'd like to see amended into the bill language to say that, pulling it up.
You have time.
Sure thing. Language that that the case may relate to climate change or greenhouse gas emissions. And I think you could still achieve what you seem to be trying to do with the bulk of this legislation by adding that in. And we see that, like with House Bill 79, that this body is already dealing with the question of damages related to CCS. And we think it's within the same idea that we can protect the cases, protect the people who would be seeking those cases, while still maintaining the goals of the author in this bill. Thank you.
Thank you very much. There are no questions. The board is clear, and we can bring the author back to the table. I forgot to read in a hurry there. We have green cards in support not wishing to speak. George H. Guidry with Koch Companies. Chris Colon with Woodside Energy, also in favor, not wishing to speak. Johnny Koch with Atmos Energy, also in favor, not wishing to speak. Sarah Rhodes with Phillips 66, in favor, not wishing to speak. Adam Haddocks with Louisiana Pulp and Paper Association, in favor, not wishing to speak. J.C. Juneau with LLRC, in favor, not wishing to speak. Sarah Rhodes with Shell, in favor, not wishing to speak. Carrie Koch with Atmos Energy, in favor, not wishing to speak. Scott Simon, Americans for Prosperity, in favor, not wishing to speak. Kevin Simpson with Shell, in favor, not wishing to speak. Renee Almore with LMTA, in favor, not wishing to speak. I would think that's even after the amendment. Harrison Getz, also in favor with GNO Inc., in favor, not wishing to speak. Chet Chasson with the Port Fouchon, in favor, not wishing to speak. Jody Monalero with Energy, in favor, not wishing to speak. Eric Morvant with Energy, in favor, not wishing to speak. Jenny Walker, Institute for Legal Reform, U.S. Chamber of Commerce, in favor, not wishing to speak. And Pat Raleigh with the Chemistry Association, in favor and willing to provide information if requested. You did a good job with green cards there, Mr. Chairman. Senator Jenkins with a question.
You know, this is, thank you, Mr. Chair. It's something of a new concept for me, so I'm really trying to pick up on it. And you may have touched upon it, but I just want to try to get a little clarity in my mind here. So, and I know that the bill is supposed to be prospective only. So, are there any claims that you're aware of in Louisiana that fits the definition of what this bill is trying to prevent?
So Senator Jenkins, there are not, but there are 40 claims currently across the country in other states. And seeing that, Oklahoma and Utah have already done legislation to get out in front of that. And that's what we're trying to do here, is to put up that block ahead of time before we get a claim from a municipality or an individual. As I mentioned earlier, the heirs of the lady who died from the heat stroke. Before we get one of those claims, we want to go ahead and get out front to be sure that they know you can't bring that claim in this state. And we didn't mention the defendants. We didn't exempt people. We just said you cannot bring that claim, and that's also at the end in line 26.
Right, and so, and I'm trying to envision some of these claims, because like I said, it's kind of a new concept to me, and I understand the example you're giving about the heat stroke. So how does this work if there is a company that has a permit and they're not to exceed a certain amount of emissions or whatever the case may be, and they exceed those emissions, and for some reason, an individual feel like they've been damaged in some regard. Is that covered in here?
No, that's a great question. And on page 3, line 15, it says a violation of any enforceable Louisiana or federal statutory limitation against emissions of greenhouse gas. That's an exception, so you could still bring that claim. If I live across the street from a petrochemical company or an oil company or whatever, and they exceed what is allowed by law in state or federal, I still have a right for that claim.
And as far as administrative type actions, am I hearing right? Like, if this doesn't prevent a governmental agency from enforcing its rules against a company?
That's correct. All of that is in here. Nothing that's in statute or federal law, Clean Air Act, Clean Water Act, OSHA, any of that is not affected in this bill at all.
All right. And I'm sorry to ask you these questions.
It's great questions.
I mean, I've been fighting so hard on redistricting, I didn't get a chance to read this bill, so I'm just trying to make sure.
Senator Jenkins, they are great questions, so keep on going.
Right.
They are very good
questions.
questions.
Just really wanted to kind of make sure that, I'm always a little concerned about putting limitations on people's rights to bring action.
And Senator Jenkins, I agree with you. And to the Sierra Club's point of, or maybe it was the gentleman talking about private property rights or the right to, not private property right. We have private property rights to be able to seek damages for something that happened on your property or whatever damages you wanted to seek. We were very, very clear to not take away the ability to do that. The only thing this pertains to is a climate change case based off of greenhouse gas emissions, and both of those are defined, to the gentleman's point, which I think he missed on page 2, line 12 defines climate change very specifically, and then on page 3, line 1 says caused by greenhouse gas, and it also defines that very specifically. This bill is very narrowly drafted.
Okay, all right. I appreciate you answering those questions. Thank you, Mr.
Great
Chairman.
questions,
Thank you, Senator Jenkins. And Mr. Chairman, just to clarify, again, Clean Water Act permits, Clean Air Act permits, EPA, DEQ permits, state permits, federal permits, they all still have a cause of action because you broke the permit somewhere.
That's correct.
This is just for a novel claim of climate change.
That is correct.
Okay. Senator Allen with a question.
Not a question. Thank you, Mr. Chairman. Just want to make a motion to report HB 804 as amended.
I see no other questions. Mr. Chairman, are you going to let us go with that, or are you going to?
I think we can go with that. If there were any other questions, I'd be glad to answer them, but I know you have a
There are
long
no
day
other
ahead
questions
of
at the time, so it's the appropriate times. Senator Arlen makes a motion to report HB 804 as amended. Is there any objection? Here, no objection. HB 804 is reported as amended.
Thank you, Mr. Chairman, and for your amendment and for your work today on that. Thank you.
Thank you, Mr. Chairman, as always. I appreciate your work.